Good morning, everyone. My name is Nausica PALAZZO. I am a postdoctoral researcher at Hebrew University. And the title of my chapter is The EU Family. Is marital status emerging as a prohibited ground of discrimination? And one would be inclined to say no, to answer no, because member states fully retain their competence over substantive family law, therefore over family status and the benefits attached to it. However, in the past few years, I have noticed that from time to time, the Court of Justice is actually employing the typical lines of reasoning, concepts, and theories associated with marital status discrimination, and that the most, let's say, progressive courts throughout the world, such as the Court of Canada, Supreme Court of Canada, use when it comes to tackling the discrimination suffered by non-marital families. Therefore, I look at three key areas where family definitions matter to understand whether and the extent to which marital status is de facto emerging as a prohibited ground of discrimination in the European Union. I look at the area of employment, the area of free movement, and the area of regarding the legal treatment of the EU staff. And by marital family, I refer to every family which has not entered into marriage. Therefore, I include both informal cohabitants, but also registered partners and parties which have formalized the relationship through means other than marriage, such as contracts. And I can anticipate that the answer in the area of free movement is no. So that's the area where the court is really still very reluctant to use those typical lines of reasoning associated with marital status. It's even fairly reluctant to protect non-marital families, including same-sex couples, through other means. So that's an area where I wouldn't look to understand if the court is willing to make strides in the protection of non-marital families. By contrast, a different conclusion is warranted in looking at the area of employment. That's an area where the court is really issuing interesting decisions. An example being the High decision regarding a paxé couple, where the court has conducted the comparability assessment. So again, a typical task of judges trying to tackle marital status discrimination. So has conducted the comparability assessment to understand whether the paxé couple was comparable to the married couple in order to confer upon this paxé couple family benefits. And that's answered yes, they were comparable, because one should not look at the attributes of the family regime, so whether the family regime has the same benefits of marriage, but one should look at the couple itself, whether it has formalized its commitment, whether the couple is unrelated, and whether it has access to whether that family regime is the only regime to which the couple has access to. But more interesting for purposes of my analysis is the area of the legal treatment of the EU staff. And this, of course, doesn't come as a surprise, because that's an area where the court doesn't intrude upon the domestic family law regimes of the member states. It merely issues decisions regarding the workers of the EU and their legal treatment. But nonetheless, this is really an area where notable advancement have been made, and where the court has really shown a growing familiarity with those conceptual tools and theories associated with marital status. An example being the familiarity with so-called functional recognition. So the emphasis the court routinely places in this area with commitment, with actual commitment, rather than formalities. And another example of this increasing familiarity is actually the fact that the court has read in the treaty the prohibition to discriminate based on marital status in a recent decision, and has argued that Article 19 prohibits to discriminate based on sexual orientation and marital status, despite there being no such mention in Article 19 of the treaty. So to conclude, if one were to ask, is there a uniform definition of family free from discrimination in the EU? The answer would be no, because the court, as you see, takes different approaches to the issue, depending on the area. But I would say that the area of employment and the area, especially the area regarding the treatment of the illegal staff, Allow me to conclude that the answer is yes. Marital status is de facto and slowly but growingly emerging as a ground of discrimination in the European Union.